Because if there is even a single conflict between the two, the document wins and your family suffers the consequences. Here are the 5 locations where these documents are hidden right now. Number 1, your 401k or 403b. If you ever worked for a corporation, a school district, a hospital, or a government agency, you have a retirement plan with a beneficiary document on file. The average 401k balance for Americans between the ages of 60 and 69 is $232,000. That entire balance is governed by the beneficiary form. Your will has no authority over it. Your trust has no authority over it. The form is the only document that carries any legal weight. Number 2, your IRA. Traditional Roth, SEP. It makes no difference. Every IRA carries a beneficiary designation, and here's the trap that ensnares more retirees than almost anything else. If you transferred your old 401k into an IRA when you retired, the beneficiary designation did not transfer along with it. That original form remained at your former employer. When the funds arrived in the new IRA, you signed a brand new beneficiary form at the IRA custodian. Perhaps you filled it out carefully. Perhaps you checked a box hastily because it was one of 15 documents placed in front of you that day. If you cannot recall precisely who you named on that new form, that is the problem. Number 3, your life insurance policy. The average life insurance death benefit in the United States is $350,000. That payout goes directly to whoever is listed on the beneficiary form, and life insurance policies are where this problem becomes most devastating, because people purchase these policies when they are young and hold them for decades. A woman in Ohio lost her husband after 32 years of marriage. He held a $250,000 life insurance policy. She assumed it belonged to her. They had shared their lives for over 3 decades, but her husband had originally purchased the policy during his first marriage and had designated his first wife as the beneficiary. He never revised it after the divorce. He never revised it after the remarriage. For 32 years, that document sat in a filing cabinet bearing the wrong name. His second wife, the woman who stood by his side for 32 years, received nothing. The first wife, with whom he had not communicated in decades, cashed the check within 60 days. Number 4, your bank accounts. Most banks offer a feature called payable on death, and many seniors enroll in it without fully grasping what it does. A payable on death designation transfers your entire bank balance directly to the named individual upon your death. It bypasses probate entirely. It also bypasses your will entirely. You may have added this to your checking or savings account years ago because the bank presented it as a straightforward way to sidestep probate. But if the person you designated is no longer the right choice, or if your family circumstances have evolved, this document is silently overriding your entire estate plan right now, and no one will discover it until you are gone. Number 5, this is the most dangerous one I referenced at the beginning of this video. Your brokerage account. If you hold stocks, bonds, mutual funds, or ETFs at a firm such as Schwab, Fidelity, or Vanguard, there may be a transfer on death registration currently on file. Some of these accounts hold $300,000, $500,000, or even over $1 million. This document routes the entire account balance directly to whoever is listed, with no court involvement, no probate process, and no consideration of your will whatsoever. Seniors who established these accounts in their 50s and never revisited them are sitting on a ticking time bomb for their families. And because brokerage accounts often appreciate considerably over the decades, the amount at stake today may be 3 or 4 times greater than it was when you originally signed the form. Now let me walk you through the 4 errors that cost families the most money. The first mistake is designating your estate as the beneficiary rather than a specific individual. This may seem logical, but it is one of the most costly errors in estate planning. When you name your estate, the retirement account gets drawn into probate. That means attorney fees, court expenses, and delays ranging from 6 months to over a year. But the real damage is the tax consequence. When a spouse inherits a retirement account directly through a beneficiary form, they can roll it into their own IRA and continue deferring taxes for decades. When the estate inherits it instead, that spousal rollover option vanishes entirely. On a $300,000 IRA, This single mistake can generate over $75,000 in accelerated federal income taxes that your family would never have owed had the form simply listed a name rather than the estate. The second mistake is failing to update after a divorce. In most states, a divorce does not automatically remove your former spouse from a beneficiary designation. Some states have statutes that revoke a spouse upon divorce for certain categories of accounts, but the regulations are highly inconsistent and they do not apply to employer retirement plans governed by federal ERISA law. Federal law supersedes state law in those situations. If your former spouse remains on the form, operate under the assumption that they will receive the funds until you contact the institution and confirm otherwise. The third mistake is designating minor children or grandchildren directly. If you list a child under 18 as a beneficiary, the financial institution cannot legally distribute the funds to them. A court will be required to appoint a legal guardian to administer the assets on the child's behalf. That triggers court supervision, annual reporting requirements, attorney involvement at every stage, and guardian fees that can consume $20,000 to $30,000 from a $200,000 account before the child ever receives a single cent of it. The fourth mistake is the one that converts all of this into a tax emergency. Prior to the year 2020, if your child inherited your IRA, they could distribute the withdrawals across their entire lifetime. A 45-year-old inheriting a $500,000 IRA could take modest withdrawals over 4 decades and allow the remaining funds to continue growing tax-deferred. But Congress revised the rule. Now, most non-spouse beneficiaries must fully liquidate the entire inherited IRA within 10 years. Let me apply real figures to this. Suppose you have a $500,000 traditional IRA and you leave it to your son, who earns $120,000 per year. Under the 10-year rule, he must withdraw the entire $500,000 within a decade. If he takes $50,000 annually, that elevates his total taxable income from $120,000 to $170,000. At that threshold, he advances from the 24% federal tax bracket to the 32% bracket on those distributions. Over 10 years, that 8% differential alone costs him $40,000 in additional federal taxes, and that excludes state income taxes layered on top of it. Therefore, your beneficiary designation does not simply determine who receives the money. It determines how quickly the IRS claims their portion. If the form is incorrect or if it names the wrong individual in the wrong way, your family absorbs the maximum possible tax burden, and there is absolutely nothing they can do to remedy it after you are gone. And here is one additional reality that tends to surprise people. A power of attorney does not resolve this. Many seniors believe that if they become incapacitated, their power of attorney can step in and revise the beneficiary designations on their behalf. Most financial institutions will not permit this. A power of attorney typically authorizes someone to manage your finances and handle your obligations while you are living. It does not authorize them to alter who receives the money following your death. Therefore, the only individual who can correct a beneficiary designation is you. And the only appropriate time to act is right now, while you are still capable of making that call. Here is what to do this week. Step 1. Contact every financial institution where you maintain an account, your 401k provider, your IRA custodian, your life insurance company, your bank, and your brokerage. Ask them one question. Who is currently listed as the primary and contingent beneficiary on my account? Do not guess. Do not rely on your recollection of what you believe you submitted years ago. Obtain the actual name that is on file at this moment. Some institutions can provide this information by phone. Others will mail or email you a copy of the form. Either way, secure it in writing. Step 2. Compare every single document to your current will or trust. Place them side by side. If any name on any form does not align with your estate plan, the form is what the institution will honor, not the will. Revise the form without delay. Step 3. If you have a revocable living trust, consult your estate attorney about whether any of your retirement accounts should designate the trust as beneficiary rather than an individual. This is not always the optimal approach because of the tax implications already discussed, but it must be a deliberate and informed decision. not an oversight left over from a document you signed 15 years ago and never examined again. Step 4. If you have experienced a divorce at any point in your life, review every form across every account, including the ones you are convinced you already revised, particularly the employer retirement plan and the life insurance policy. Those are the two that families contest in court more frequently than any others, and those are the two where the incorrect name carries the greatest financial cost. Step 5. Do not designate minor children or grandchildren directly as beneficiaries. Designate a custodian under your state's Uniform Transfers to Minors Act, or designate your trust with explicit provisions governing how the funds should be administered until the child reaches the age you select. One phone call to the institution holding your largest account could protect your family from a $400,000 loss. So make that call before the end of this week. There is one document that overrides your will every single time. And if you have not reviewed it within the last 12 months, your entire estate plan could already be routing your money to someone you never intended to receive it. It does not matter how much you paid your attorney. It does not matter how thoroughly your will was prepared. It does not matter if you revised your will just last month. If this one document says something different from your will, this document wins. Not occasionally. Not in certain jurisdictions. Every single time. Federal courts have ruled on it. State courts have ruled on it. The United States Supreme Court resolved it unanimously. The document overrides the will. But here is what your estate attorney likely never told you. There is not just one of these documents. There are at least 5 distinct versions concealed inside accounts you already hold. And the most hazardous one lives inside an account most seniors have not reviewed in over a decade. By the end of this video, you will know precisely where all 5 are hidden, what they govern, and the one oversight that transforms a straightforward document into a $400,000 catastrophe for your family. This document is called a beneficiary designation. You completed one the day you enrolled in your 401k at work. You completed another when you purchased your life insurance policy. Your bank may have asked you to fill one out. Your brokerage may have one on record. You signed these documents years ago, probably gave them no further thought. And that is precisely where the trouble begins. A beneficiary designation is a legal agreement between you and the financial institution that holds your assets. It instructs that institution on one thing only: who receives the money upon your death, and when you pass away, the institution follows that document. Not your will, not your trust, not a handwritten letter, not a verbal commitment you made to your children around the dinner table. They honor the document because legally it functions as a contract, and contracts supersede wills. And here is the element that makes this so particularly dangerous. The financial institution does not conduct any investigation. They do not contact your family. They do not consult your will. They do not pause to consider whether the person listed on that document is still the person you would choose today. They see a name, they transfer the funds, and once those funds have been transferred, recovering them is nearly impossible. This is not a legal loophole. This is federal law. Let me illustrate just how severely this can go wrong. A man named William Kennedy worked for DuPont for more than 20 years. He held an employer retirement plan valued at over $400,000. When he first enrolled in the plan, he designated his wife as the beneficiary. That was a reasonable decision at the time. They were married. She was the natural choice. Years later, they divorced. Following the divorce, Kennedy did what most conscientious people do. He visited his attorney and rewrote his entire will. He made it absolutely clear that everything was to go to his daughter. He signed it. It was notarized. It was legally valid in every respect. But he never contacted DuPont to revise the beneficiary designation on his retirement plan. He may not have even recalled that the form existed. It was a piece of paperwork he had signed 2 decades earlier on his very first day enrolling in the plan. When Kennedy passed away, his daughter assumed the funds were hers. The will stated so in clear language. There was no ambiguity whatsoever, but DuPont transferred the full $400,000 to the former wife because her name remained on the beneficiary form. Kennedy's daughter filed suit. She had the will. She had her father's unmistakable intent documented. The case moved through the federal courts and ultimately reached the United States Supreme Court. The court ruled unanimously. The beneficiary designation controls. The will is irrelevant. The daughter received nothing. $400,000 lost because of one document he neglected to update. And this situation is far from rare. A study by the American Association of Retired Persons found that nearly 40% of Americans with retirement accounts have not revised their beneficiary designations in over 5 years. 40%. That means millions of seniors right now have documents on file that do not reflect who they genuinely want to inherit their money. Divorces occurred, remarriages occurred, spouses passed away, grandchildren arrived, life transformed in every conceivable way, but the document remained frozen in time because nobody picked up the phone and made the change. Therefore, the question every senior needs to answer right now is not whether your will is current. The question is whether every beneficiary designation across every account you own aligns with what your will actually states.